Why that TV's not coming on? Yeah, it's not. Here we go. We're good. I still ain't picking it up. Might have something unplugged over there, Ronnie. All right, well, we'll get started with the people that are not in the courtroom. I mean, are not on Zoom anyway. So good morning, everybody. Just a couple real quick announcements, admin announcements before we get started. We're going to go ahead and take open announcements on the 9 o'clock docket that are in the courtroom first. The inmates are in their masks. I do that in case you as an attorney don't want to encounter someone that doesn't have a mask, but you can wear a mask if you want. You don't have to wear a mask if you don't want to. Whatever you want to do for your own personal safety to protect you against the Chinese coronavirus. So with that, I'll take open announcements on the 9 a.m. docket. Yes, sir.
There's a here on arraignment for Michael. They are 19.
What page is it on? What's the defendant?
David Michael Wayne.
All right. I got you. This is cause number CR 19-0609-173, the state of Texas versus David Wayne, set for arraignment. Is Mr. Schmidt?
Yes.
Yes, sir. Go ahead.
Judge, we've received a copy of the indictment. I reviewed it. Mr. Wayne's name is spelled correctly. We waive formal reading. Ask that we enter a plea of not guilty, ask the matter be reset.
All right, then, Mr. Wayne, the court notes your plea of not guilty for purposes of arraignment. You're going to receive 2 new court dates in writing. Those are May the 12th at 1:30 for discovery status, and then again on June the 9th at 1:30 for pretrial. And so as soon as you receive your 2 reset notices, sir, you're free to go, as long as your attorney's finished with you.
Thank you, sir. Judge, you see?
Yes, sir. Okay, Mr. Mills.
Page 2, your victim, or person is Keandre Barlow.
We have Mr. Barlow here, Your Honor.
All right, I'm gonna get you in here. Thank you, sir. If you can get him in the seat. Mr. Barlow, you got me?
Yes, sir.
All right, I'm going to call your case then. This is cause number CR 20-0612-173, the state of Texas versus Keandre Barlow, and that is set for arraignment. Mr. Mills.
Your Honor, Mr. Barlow's name is spelled correctly in the indictment. We'll waive the formal reading of the indictment, enter plea of not guilty to the charge.
All right, then, Mr. Barlow, the court notes your plea of not guilty for purposes of arraignment. Your 2 next court dates are May the 12th at 1:30 for discovery status, and then again on June the 9th at 1:30 for pretrial. And so make sure you stay in touch with Mr. Mills and
Where is he, Judge?
Orange County.
Orange County?
Yes, sir. And so whenever you're finished, can you still hear me, Mr. Barlow? Looks like he froze up. Well, I think we got him arraigned. He was present and could see
He
you.
was arraigned, yes, sir.
All righty. Yep, he is froze up. When he comes back on, if he does, I'll tell him. Well, I've already taken his plea of not guilty. All right, who else you got?
The next one is Jason Passons. He's present.
All right, these are cause numbers CR 21-0043 and 0044-173, both styled the state of Texas. versus Jason Passons, and both set for arraignment. Mr. Mills.
Your Honor, Mr. Passon's name spelled correctly in both indictments. He understands what he's charged with. Will waive reading the indictment, plead not guilty to both charges, not true to both enhancement paragraphs.
All right, sir, the court notes your plea. Mr. Barlow, if you'll hold on just 1 second, I moved on without you, but we'll wrap back around to you.
Yes, sir.
Mr. Passon's court notes your plea of not guilty to each case, as well as not true to any enhancement paragraphs. Your two next court dates are May the 12th for discovery status, and then again on June the 9th for pretrial, and both of those are here in the courtroom at
Judge,
1:30.
I'm sorry, I didn't hear that a minute ago. Is there another day besides the 12th? I'm leaving on the 12th for vacation.
You know that.
12th through the 19th. I can't hear what he said.
status and pretrial.
June 9th, that's fine.
All right, so I take that back, Mr. Passons. You're going to receive reset notices for June the 9th at 1:30 for each case, and we'll hear discovery status and pretrial on that date. However, Mr. Passons, before you go, due to the nature of your charge, I'm going to order you to take a drug test today. You'll go with probation, take the test. Don't leave when you're done. Come back in here, and then we'll all go the results together.
Okay.
Thank you, sir. All right, Mr. Barlow, you back with us? Here he is. Can you hear me again, sir? Mr.
Oh,
Barlow?
yes, sir. Yes, sir.
I don't know where we left off, but I had entered your plea of not guilty and given you a new court date. It's actually going to be June the 9th at 1:30
Yes, sir.
for discovery status and pretrial. And are you close to taking care of your business there in Orange County, or do you know?
I don't know quite, but I meet with my lawyer pretty soon. Maybe this week, at the end of this week, or beginning of next week.
Okay, just make sure your lawyer knows that you're set here for June the 9th. And whoever that is, tell them to get in contact with Mr. Mills, and maybe they can figure out how to work this out together.
Okay, and would I be coming down there in June?
Well, it depends on what you got there and when it is. I can't tell you that. I'd rather have you here, but I know you're there.
Okay.
All right.
Yes, sir.
All right. Thank you, sir.
All right.
Yeah. Hang on 1 second. I'm closing out a Zoom hearing now.
I don't know why I can't mute anybody. It's not giving me the option. Yeah, make me back the host if you don't mind.
Isn't it the, what was this guy's name in Minneapolis?
Oh, you got that one right.
There we go. I guess I hit the wrong button. All right, who else you got?
I'm sorry, Mr. Price, Daniel Price is on page 3.
Daniel Price. All right, these are cause numbers CR 20-0615-392 and CR 21-0203 through 0205-392, all style the state of Texas versus Daniel Price. And the CR 21 cases are set for arraignment, so let's go ahead and handle that.
Judge, I don't, do you have a possession indictment back there? The possession, 0615.
That's a pretrial case.
Oh, is that the pretrial case?
Yeah.
Okay,
That's not the new one.
I got you. Judge, Mr. Price understands what he's charged with, and these charges, that is right on your name. Name is spelled correctly. We'll waive formal reading of all indictments. Plead not guilty to all charges and not true to all the enhancement paragraphs.
All right, sir, the court notes your plea of not guilty as well as not true to any enhancement paragraphs. On each of these cases, your two next court dates on these are May the 12th at 1:30. Nope, sorry, June the 9th at 1:30 just one next new court date, June 9th, 1:30 for discovery status and pretrial. And then on that PCS case, you just want to pass that.
If
to
that we
June
can do
9th.
that, just put it on pretrial same day.
And then what I'm going to do, Mr. Price, you're set for pretrial on that older case. I'm just going to go ahead and move that to the June the 9th date so we can take care of all that together. Is that all right with you? All righty. Got a couple more. At least one more, I think. Got a couple. Rucker.
The next page, Keith Rucker.
Keith Rucker. Keith Rucker. These are cause numbers CR 20-0656 and 0657-173. Both styled the state of Texas versus Keith Rucker. Mr. Rucker, come on up. I just called your cases. And both of these cases are set for arraignment. Mr. Mills.
Your Honor, Mr. Rucker's name is spelled correctly.
Yes.
He understands what he's been charged with in the cases. Will waive formal reading of both indictments, enter plea of not guilty to the charge and not true to the enhancement paragraph.
All right, then, Mr. Rucker, the court notes your pleas of not guilty to each indictment, as well as your plea of not true to any enhancement paragraphs. Your next court date is June the 9th at 1:30, and that's for discovery status and pretrial. And so you're going to get that reset notice, but based upon the nature of your charge in that 0656 case, I'm ordering you to take a drug test today. You'll go over with probation, take the test. When you get done, don't leave. Come back in the courtroom and we'll go over the results together. Okay, sir?
My last one, Judge, is David Zuniga.
Zuniga, come on up, sir. This is cause number CR 20-0697-173, state of Texas versus David Zuniga. And that is set for arraignment. Mr. Mills.
Judge, his name is spelled correctly in the indictment. He understands what he's charged with. Will waive the reading of the indictment, and plea of not guilty to the charge and not true to both enhancement paragraphs.
All right, then, Mr. Zuniga, the court notes your plea of not guilty and not true to the enhancement paragraphs for purposes of arraignment. Your next court date is June the 9th at 1:30 for discovery status and pretrial. So if you get out of jail between now and then, I need to see you back here on June the 9th at 1:30. All right. All you got, Mr. Mills?
I think that's all I have till this
All
afternoon.
right, we'll see you then. Thank you, sir. Ms. Thompson.
To the Diana Sistrunk.
Cheyenne Sistrunk. Cheyenne Sistrunk. This is cause number CR 21-0024-173, the state of Texas versus Cheyenne Sistrunk, set for arraignment. Is there a Cheyenne Sistrunk in the courtroom? I hear no answer. Is there a There's no Cheyenne Sistrunk in the lobby. Is there a Cheyenne Sistrunk appearing via Zoom? I see nor hear no one. The time is now 9:09. This was set for arraignment at 9 a.m. She does have a bondsman, appears it's Farmer Bonds. And so the court will entertain a motion.
State moves for bond forfeiture.
Granted, in case this will issue, she'll be held with no bond. And Ms. Thompson, I'll be here all day if you can find her.
Yes, sir. I'm in Van Zant the afternoon, you know. So I understand. I got another one, Your Honor. Christopher Curtis will be a plea this morning.
Okay, Christopher Curtis. Okay, Mr. Curtis, if you'll step just right over there to the end of the table, the clerk needs to swear you some documents. Kind of quiet this morning. Normally it's kind of a madhouse. I like the madhouse. You like it? No, I like the.
This afternoon.
This is my first lawyering experience was in a family violence court in Dallas. And so I was used to it was a madhouse. Ronnie likes to fish on smooth water, don't you, Ronnie? Made that up. You like that? Yeah, I like a little choppy. So. Not when I'm fishing, I know. I mean, we're almost in April of 2021. Can you believe that? Oh, he wasn't signed up already?
Yeah, he signed up, yes.
Oh, I got you. It's okay. I'll go ahead and sign them while you're doing that.
I know, no. Step back. Couple step back to get the-
Are we ready? Y'all good? All righty, I'll call it. This is cause number CR 20-0266-173. State of Texas versus Christopher Charles Curtis. And that is set today for a plea. Is the state ready?
We're ready, Your Honor.
And on behalf of Mr. Curtis.
We're ready,
Ready. Sir, is your name Christopher Charles Curtis?
Yes.
And you're gonna have to talk a little louder. I know we got that mask on you. But sir, are you the same person that was originally indicted by Henderson County Grand Jury for the state jail felony offense of attempting to take a weapon from a peace officer?
Yes, sir.
I can get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
And you can lower your hand. Mr. Curtis, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes.
If it turns out you're not a U.S. citizen and you enter into this plea bargain, it could have certain negative immigration consequences. Do you understand that?
Yes.
And Mr. Curtis, have you ever been treated for any mental health or emotional issues?
Yes.
And what would those be, if anything, that you were diagnosed with?
Bipolar depression by self-medication.
Self-medication? Are you on any prescribed medication?
Yes, sir.
And are you receiving that medication okay, and from the jail?
Yes, sir.
And you understand what's going on in here? And Ms. Thompson, how long have you represented Mr. Curtis?
Your Honor, for over a year now.
Okay. And or do you feel that he's competent?
Yes, sir, he is competent.
Well, Mr. Curtis, even though you've told me you've had this diagnosis and you had in the past self-medicated, the law presumes you're competent and based upon your demeanor, your answers to my questions, and the statements from your attorney, the court's going to find you are competent. Mr. Curtis, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
Yes, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a state jail felony. A state jail felony carries a punishment range of not less than 180 days nor more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
You do?
Yes, sir.
All right. And the plea bargain?
Your Honor, it's 12 months confinement in the state jail felony facility with credit to 387 days served. He's responsible for attorney's fees and court costs. We're also asking the court to consider an unindicted criminal trespass and an unindicted resisting arrest from the same offense state.
Is that your understanding of the plea bargain, Mr. Curtis?
Yes. Yes.
Is that your understanding, Ms. Thompson?
Yes, sir, it is.
Mr. Curtis, a few minutes ago, you told me you could read and write the English language. I've got two documents here I want to go over with you. First is the agreed plea recommendation. Did you read both the front and the back and sign the front and the back of that document.
Yeah, yes, sir.
And do you have any questions about it? The next document I want to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that with Ms. Thompson?
Yes, sir.
And did you sign that second page?
I did, yes.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents you went over with Ms. Thompson related to this
I'm
plea?
fine with everything.
You fine with everything?
No,
Well, do you have any questions?
no.
All right, well, if you read and went over these with Ms. Thompson, I know she explained to you that you have many constitutional rights, including the right to trial by jury.
Yes, sir, I understand that.
You want a jury trial?
No, sir, it's just resolved.
You want a plea bargain?
Yes, sir.
Then I'll ask you, sir, how do you plead to that state jail felony offense of attempting to take a weapon from a peace officer as
I
alleged
signed
in the
guilty,
indictment?
sir. Guilty.
Hold on, let me finish the question because
Okay,
she
excuse
can't
me.
take us both down at the same time.
Your Honor, he just recently has suffered from Bell palsy, so
Okay.
he's having some difficulty.
I understand. Well, I mean, but that's just with his
Yes, sir.
expressions, not with his understanding.
Yeah, yes. sir.
Okay.
Sorry.
So you understand everything I'm saying. So how do you plead, sir? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir. I need to be,
Not hear the evidence.
Your Honor, I have states 1 an offense report and states 2 is my warrant compliance.
No objection, Your Honor.
Yes, we can put it through that. So, admitted.
It's like playing Operation, try not to hit the microphones.
No objection, I said, Your Honor.
Admitted. Anything else?
We rest and close.
Ms. Thompson?
Rest your close, Your Honor.
All right, then, Mr. Curtis, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense as alleged in the indictment. The court will follow the plea bargain, and sentencing you considers those unindicted cases that are annotated on the plea sheet, sentences you to 12 months in a state jail felony facility. However, you have credit for 387 days as of today and orders you to pay your attorney's fees and court costs. And just a couple more things I need to go over with you, Mr. Curtis. Did you get an opportunity to review the judgment in your case?
yes, yes,
All right, is your name, the charge, and the time credit correct?
yes.
All right, and then next, Mr. Curtis, now that you've been found guilty and convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. Those are actually legal terms. And so if you have any questions about what those are or anything else, make sure you refer to the packet, the document in your plea packet, and or consult with an attorney. Okay, sir? Is he being held on anything else?
Nope.
I don't see a release in here.
I can get the court one, Your Honor.
All right, because, and he did that, so, all right, sir, you're now remanded back to the custody of the sheriff for release on this charge unless you are being held on another. You didn't get that from the vaccine, did you? Because that could be a side effect.
No, sir, I don't know, you come up on.
I know, I've heard that.
I had an offer today.
All right, sir, you need to see Mr. Halbert for thumbprint and good luck to you.
Your Honor, that's all I have. May I be excused?
Yes, ma'am.
Thank you, sir.
Mr. Harrington. Mr. Hutchins. Come on up, sir. All right, this is cause number CR 21-0061-173, the state of Texas versus David Hutchins, set for arraignment. Mr. Harrington.
Your Honor, he has reviewed the indictment. His name is spelled correctly. He understands the charges. We'll waive the formal reading of the indictment and plea of not guilty this time.
All right, Mr. Hutchins, the court notes your plea of not guilty for purposes of arraignment. Your two new court dates are May the 12th at 1:30 for discovery status, and then again on June the 9th for pretrial, also at 1:30. And so as soon as you receive those reset notices, sir, you're free to have a seat. And if you get out of jail between now and then, I need to see you back on May the 12th.
Yes, thank you, sir.
Yes, sir.
I do excuse this time, Judge.
Yes, sir, appreciate it. Mr. Stevens?
David Rockmore?
Should have looked at the page number.
Got it. Top page 9. Mr. Rockmore. All right, this is cause number CR 21-0035-173, the state of Texas versus Jalen Rockmore. Set for arraignment, Mr. Stevens.
Your Honor, for purposes of arraignment, his name is spelled correctly on the indictment, understands the nature of the charges against him, waives formal reading of the indictment, enters a plea of not guilty.
All right, Mr. Rockmore, the court notes your plea of not guilty for purposes of arraignment. Your 2 next court dates are May the 12th at 1:30 for discovery status, and then again on June the 9th at 1:30 for pretrial. And so as soon as you receive those reset notices, you can have a seat. And if you get out of jail between now and then, I need to see you on May the 12th at 1:30.
Randall Mingy.
Mr. Mingy,
Show.
cause number CR 21-0011-173, the state of Texas versus Randall Mingy. Is there a Randall Mingy, easy pickings bail bonds? Is there a Randall Mingy in the courtroom? I hear no answer. Is there a Randall Mingy appearing via Zoom? I see no one nor hear no answer. And no answer in the lobby. The time is now 9:22. Arraignment was set for 9 a.m. I'll entertain a motion.
State moves for bond forfeiture, Your Honor.
Granted, case will issue, he'll be held with no bond. And Mr. Stevens, I'll be here all day if you can find him.
And then Cody Parker, Your Honor.
Cody Parker. He's in Garza County.
Oh, is Randall
Right.
Mingy or Parker?
Garza. I've never heard of Garza County.
Post text.
Post. Heard of Garza.
Is that on Mr. Parker?
Yeah.
In
I'm
your
gonna
honor,
call it anyway. Cause number CR 19-0938-173 and cause number CR 21-0265-173. Both styled the state of Texas versus Cody Parker. It's my understanding he's in Garza County. And so if the state could file a bench warrant with the court will sign it. Yes, sir. I think I asked to do that last time, didn't I?
previously on a PR bond, and then he didn't show. and they-
Y'all can do a bench warrant on him. I'll sign it and we'll see if Garza County can let us have it.
Let's reset.
Mr. Garza or Mr. Parker? Mr. Garza is probably dead if the county's named after him. I would assume.
15th. Yeah, 9 o'clock.
Tax day, 9 a.m., April 15th.
9.
I don't know what code I don't know what we do anymore. But the government just hands out money now. They just take mine and hand it out to everybody else.
I guess so.
Print it. Both parties, both are responsible.
Your Honor, I'm probably fixing to be appointed on a Daniel Snyder or Donald Snyder, and since I'm at the front of the line, I figured I'd do his arraignment, and if he doesn't qualify, then he's already been taken care of.
I got you. Who is it?
Donald Snyder, and I'm trying to find him also.
With Mr. Snyder,
looks
I
like-
presume?
Page 4.
Mr. Snyder?
Yeah.
All right, I'm gonna call your case for arraignment, sir. I don't know whether you qualify yet or not, but we're gonna arraign you. CR 21-0027-173. The state of Texas versus Donald Snyder, set for arraignment. And just for the record, I think he's filled out the paperwork. Mr. Stevens, if he does qualify, you'd be his attorney.
That's
If you
correct.
don't qualify, do you mind at least handling the arraignment?
No, sir.
All right, and then Mr. Snyder, do you mind him handling your arraignment?
No.
All right, go ahead.
Yeah. You understand what they've alleged you've done, correct? Not that you're guilty, but what they've alleged you've done. The possession less than a gram. Yeah. Okay. Your Honor, for purposes of arraignment, his name is spelled correctly on the indictment, understands the nature of the charges against him, waives formal reading of the indictment, and enters a plea of not guilty.
All right, Mr. Snyder, the court notes your plea of not guilty for purposes of arraignment. Your 2 next court dates are May the 12th for discovery status at 1:30 and then again on June the 9th for pretrial, also at 1:30. And so you're going to receive 2 reset notices there. We'll let you know if Mr. Stevens does, or if you do indeed qualify for a court-appointed attorney. If you do not, and you have to hire someone, make sure you give them those reset notices.
I was just notified that he doesn't.
He does not qualify. And so, Mr. Snyder, you're going to have to hire an attorney. Make sure that you give them those reset dates. But before you go, due to the nature of your charge, I'm going to order you to take a drug test. You'll go take a drug test with probation. When you get done, don't go anywhere. Come back in the courtroom so we can go over the results together. Okay, sir?
Okay. That's all that before the court, maybe excuse.
Yes, sir.
I'll put the indictment back in.
Stevens.
This is Roberts, Your Honor. I think around page 7.
All right, these are cause numbers CR 19-0313 and CR 21-0036-173, both styled the state of Texas versus Ulysses Roberts. And, let's see, the newer case is set for arraignment, so let's go ahead and handle that. Mr. Stevens.
If it may please the court, Your Honor, my client would advise that he understands the nature and consequences of the charges against him. He would advise the court his name spelled correctly. Will waive reading of the indictment, enter a plea of not guilty to the indictment and not true to the enhancement paragraphs.
All right, Mr. Roberts, court notes your plea of not guilty and not true. Your 2 next court dates on this case are May the 12th at 1:30 for discovery status. And then again on June the 9th at 1:30 for pretrial. And so let's go ahead and move on to the pretrial. What I'm going to do is I'll just push this case so it runs in line with the other one. You okay with that, Mr. Roberts? Or will they run at the same time?
That's good, just because I was just appointed this past Friday,
Okay.
so I
And
wouldn't have
so,
been ready. for
yes,
pretrial
reset
anyway.
notices for both cases for those same 2 days.
All right, great.
All right, you can have a seat, Mr. Roberts. Mr. Benton and Mr. Upshaw.
Yes, sir, Mr. Benton next.
Okay, Mr. Benton. Where are we gonna get our TV out there?
Josh, sent me a message in the last week. Said he needed to get with me.
You should have said, you're right, you do need to get with me to talk about it.
I did.
I've been waiting for a year.
I told him.
I'll text him, remind me. Mr. Benton? All right, this is cause number CR 20-0689-173, the state of Texas versus Roderick Benton Jr. and set for arraignment. Mr. Stevens.
Yes, sir, may it please the court, Your Honor. My client would advise the court his name spelled correctly. He understands the nature and consequences of the charges against him. We will waive reading of the indictment, enter a plea of not guilty.
All right, Mr. Benton, the court notes your plea of not guilty for purposes of arraignment. Your 2 next court dates are May the 12th at 1:30 for discovery status. And then again on June the 9th at 1:30 for pretrial. And so as soon as you receive those 2 reset notices, unless your attorney needs you for something, you're free to go. And does he have conditions of bond? We know.
I'm sorry, Judge.
There should be a protective order. If not, does he have conditions of bond?
I asked him and he said there was not a protection
Well,
order. I don't know if there is or not.
He does have to.
Okay, and what are those? This is Calhoun's grand jury.
No, this case is a CR 20 case. So
That's mine?
yeah, it's yours. Defendant shall not communicate with alleged victim. No within 1,000 feet. Residence, store, other location. Defendant shall abstain from drug.
Okay, no contact with the alleged victim. Do not go within 1,000 feet of the victim's home, residence, or place of business, and no drugs that are not prescribed, illegal drugs, or alcohol, or marijuana. And so, do we have a written copy of that?
Yeah.
So, once you receive the written copy of those bond conditions, sir, Make sure if you have any questions, ask Mr. Stevens. If not, you're free to go and we'll see you in May.
Yes, sir.
He has a child with the victim, and he does exercise his visitation. So there's a time that there will be an exchange of visitation child. I mean,
I
I'm
mean,
not
in
sure
my
how to work that
experience,
out.
that's normally when the arguing happens, is when you're exchanging the child, because one's late, one's not there, the other one wants to drop off somewhere else. I've been divorced, I understand. Happily married now, but been divorced. But that's when arguments normally happen. So I'm gonna waive that part of the conditions of bond, that during exchange. But just know in your mind, that's when arguments happen. So clean break, in and out. All right. Because you do deserve to be in your child's life. Your child deserves you to be in their life. So, all right. You have any questions? Ask your attorney.
Yeah.
Anything else?
I have Willie Upshaw.
Mr. Upshaw. Willie Upshaw. Showing to be on a
I
personal
haven't seen
bond.
Mr. Upshaw yet. I haven't seen, I've called it the hallway a couple times.
They got a dirty diaper. No, they don't. Where'd these scratches come from? Cause number CR 21-0026-173, the state of Texas versus Willie Upshaw. Today is set for arraignment. Is there a Willie Upshaw in the courtroom? I hear no answer. Is there a Willie Upshaw appearing via Zoom? I see no one. I hear no answer. His name's been called in the lobby. He's on personal bond and he's not there. And so the time is now 9:32. Arraignment was set for 9 a.m. Court will entertain a motion. Granted, a capital issue, he'll be held with no bond. I'll be here all day if you can find it.
We'll try to get a hold of him because I'm back in your court this afternoon.
Address that he listed on his person.
When you're your own bondsman, it's your responsibility to find that one court.
We'll try to get you judge him.
Right. Sir,
Might be excused.
yes, sir, we'll see you. Mr. Schmidt,
Yes, Your Honor. Jeffrey Shirey is a petition for judicial clemency.
Mr. Shirey, come on up. Cause number CR 18-0256-392, the state of Texas versus Jeffrey Shirey. It's set on a petition for clemency today. Is the state ready? Well, let me ask you this, is the applicant ready?
We are, Your Honor.
And on behalf of the state,
We're ready, Your Honor.
all right, go ahead, Mr. Schmidt.
Judge, just for the record, on March 4th, 2020, Mr. Shirey was placed on probation out of this court for the misdemeanor offense of assault, family violence. He was discharged from probation on March 8th of 2021. Successfully, obviously, from probation. Mr. Larry is not here today, but I can, as an officer of the court, I'll tell you, I've spoken with him about this, and Mr. Shirey had no violations while he was on probation, and he has no position on the matter one way or the other. I would like to call my client.
All right, sir, if you could raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God.
Yes, sir.
And you lower your hand, Mr. Schmidt.
State your name to the court, please.
Jeffrey Shirey.
Okay, and Mr. Shirey, you're the same person who pled guilty to and was convicted of the misdemeanor offense of assault family violence on March 8th of 2021, correct?
Yes.
And you were placed on probation on that day, correct?
Yes.
And you successfully completed your probation on or about March 8th. You were discharged on March 8th, but you completed it a few days before, correct?
Yes.
Now, the court has two boxes that the court can check when they discharge you from probation. And in this case, the court simply discharged you from community supervision. Is that correct?
Yes.
And we're here today requesting what's called judicial clemency, correct?
Yes.
you believe you've been rehabilitated?
Yes,
Okay. And you followed all your terms and conditions of probation?
yes,
Okay. Mr. Shiry, are you working?
yes.
Okay, what do you do?
I deliver auto parts in my car.
And you've been trying to seek other employment, is that correct?
Yes.
Okay, what sort of other employment have you been seeking?
Drive for Uber, drive for Lyft, any type of retail, working in the, yeah, I pretty much denied for everything except contract work because of a filing offense.
In addition, what's your housing situation?
I haven't been able to find any single housing and I'm just bouncing around from motel to trying to find the cheapest deal from week to week.
Okay.
I've been denied for a lease a number of times and told filing offense, don't even waste your money.
I'm sorry, violent offense?
Filing offense, don't even waste your money. There's a number of felonies that they'll take, but they just said no violence.
Understand.
And so, obviously, as you said in my petition, you've had difficulty overcoming the record of conviction, and it's limited your ability to obtain meaningful employment as well as housing. Is that correct?
Yes,
And are you asking the court to grant you judicial clemency with respect to this cause?
yes,
And you understand this is not, if the court granted you judicial clemency, this is not the same as an expunction.
yes, I understand.
It would just show that you successfully completed your criminal history. If the court granted it, would show that you'd successfully completed the probation and that the charge had been then dismissed, correct?
Yes,
So it's still going to be visible to everybody.
yes,
And you understand, even though it is dismissed, the law provides that you can't go back then and petition for an expunction based upon a grant of judicial clemency for dismissal. You understand that?
yes, I understand.
Okay. That's the witness. Judge. No questions, John?
State, any other witnesses?
No, sir.
All right, you rest,
Resting.
state.
We rest in closed, Judge.
Um,
Mr. Strawn's been handling this on behalf of the state judge. I spoke with him this morning. This is completely within the discretion of the court and like.
Well, I know that, but I want to know what your
Like
position
Mr.
is.
Larry, we have no position on the matter.
Okay. Any prior criminal history?
Not that I'm aware of. Your Honor.
He has so he got in a fight 15, how many years ago?
14, 15 years ago.
Got a 3-month with a man, non-family violence offense out of Dallas County, and received a 90-day non-reporting probation for an assault. I don't know if that was a conviction or deferred.
It was deferred.
Okay. 90 days.
Other than that, nothing else?
That's correct.
The bar fight?
It wasn't at a bar, but it was with another man.
All right, anything else?
No, sir. No, sir.
All right, well then, considering the facts and circumstances of this particular situation, and the court does take these seriously, but misdemeanor, one other fight, I'm gonna go ahead and grant it.
Thank you very much.
Good luck to you, Mr. Shire.
Thank you, sir.
Please don't make me regret it. I want to read your name in the newspaper somewhere.
No, sir.
Unless it's for something successful, like you won the lottery.
Thank you, Judge. And I frankly, I've never, this is the first one of these. I've
First
ever
one
done.
I've, well, I don't know if it's the first one I've done, but I'm familiar with it.
It's my understanding that it will need to be sent to the DPS by the clerk.
Right. And it's important because it's for everybody. It encourages people to successfully complete their probation.
Sure.
And so if they've got a little carrot at the end, it might help them out.
Right. And just for the record, just so people know, you have to file it within 30 days according to some courts or
Right.
you lose jurisdiction. There's a split by the appellate courts as to whether you have to or not, but we're within.
You don't want to be the case that has a split resolved by the Court of Criminal Appeals then.
Right.
So just get it within in time.
So, thank you, Judge. I'm gonna, once it's all certified and everything, I'll get you a copy of that. Judge. So, okay, may he be excused.
Yes, sir.
And not
Good
be
luck to you,
excused
Ms. Shire.
this afternoon. Thank you.
Mr. Weiner.
Yes, Your Honor. Comment, President?
Thomas Presley. You can come on up, sir. All right, this is cause number CR 21-0030-173, the state of Texas versus Thomas Presley, set for arraignment. Mr. Weiner.
Your Honor, I've received a copy of the charging instrument. My client's name is spelled correctly. Understand the nature of the allegations alleged against him. Would waive formal reading of the indictment, enter plea of not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. Your two next court dates are May the 12th at 1:30 for discovery status, and then again on June the 9th, also at 1:30 for pretrial. And so you're going to receive your two reset notices there. However, I'm sure your attorney told you that due to the nature of your charge, I'm going to order you to take a drug test today. You'll go with probation, take the test. When you get done, don't go anywhere. Come back in the courtroom and we'll all go over the results together. Thank you, sir.
That's all I have. Pending the results, may I be excused?
Yes, sir.
Thank you.
Ms. Moore.
Which file?
Ms. Nobles,
I haven't seen her.
personal bond. All right, this is cause number CR 21-0008-173, the state of Texas versus Jessica Nobles. Is there a Jessica Nobles in the courtroom? I hear no answer. Is there a Jessica Nobles appearing via Zoom? I hear no one. I hear no answer. I see no one. And no answer in the lobby. The time is now 9:42. Arraignment was set for 9 a.m. She is on personal bond. Court will entertain a motion. Granted, capital issue, she'll be held with no bond.
Resident notes to her address listed on her personal.
Said she's her own bondsman. It's her responsibility. All right, and so again, but if you find her between now and then, you've got two other ones, Lee Floyd. Okay. All righty, I'm going to move on to the Zoom folks now. Mr. Scott, you got anything?
I've got Brandon Black now.
Okay. Anybody seen Mr. Hunt? Mr. Young? Who do we have here?
Brandon Black. Your
Oh,
Honor.
okay. Sorry, I was on the wrong page. All right, this is cause number CR 21-0005-173, the state of Texas versus Brandon Black, set for arraignment. Mr. Scott.
Yes, Your Honor. Brandon Black. Brandon Black.
Just get a copy of your indictment so you can show it to you.
John, you want to use mine?
Yes. Thank you. Brandon, take it. Your Honor, we've gone over the indictment. Mr. Black's name is spelled correctly. He understands the nature of the charge against him, waive formal reading of the indictment, enter plea of not guilty and not true to enhancement paragraph.
All right, Mr. Black, then the court notes your plea of not guilty as well as not true for purposes of arraignment. Your two next court dates are May the 12th at 1:30 for discovery status, and then again on June the 9th at 1:30 for pretrial. And so you'll receive your reset notices there. However, before you go, based upon the nature of your charge, I'm ordering you to take a drug test. Take the test. When you get done, don't leave. Come back in the courtroom. We'll go over the results together. Thank you, sir.
And I've got a couple more, Your Honor, I'm not ready on yet.
Okay.
One should be a plea.
All righty. Let's just do it this way. So Mr. Croman. Yeah, I see you, sir. You're top of the docket. I'll go ahead and handle you.
Thank you, Your Honor. Appreciate that.
All right, and you have Rebecca Lopez.
Yes, sir.
She's on Zoom. Okay, I see.
She's
Ms.
on Zoom,
Lopez.
Your Honor.
Just a moment. All right, Ms. Lopez, can you hear us? All right, you need to unmute yourself there.
I
All right.
hear you.
All right, can you see your attorney there as well?
Mm-mm. No,
All right,
sir.
Well, it's because you're on a phone. You'll be able to hear him. All right, this is cause number CR 19-0886-173, the state of Texas versus Rebecca Lopez, set for arraignment. Mr. Croman.
Thank you, Your Honor. May it please the court. Ms. Lopez understands the charge against her. She's had a copy of the indictment delivered to her. Will waive formal reading and enter a plea of not guilty, Your Honor. And Judge, I'm set for trial on May 12 in Fort Worth. If we could have both on June 9, please.
Okay. All right. Then Ms. Lopez, the court notes your plea of not guilty for purposes of arraignment. Your next court date is June the 9th at 1:30. And we'll hear discovery status and pretrial on that date. And what, can I see the arraignments? It's not drug related. Okay. All right. Well, then ma'am, again, June 9th at 1:30. We'll see you then.
Thank you, Your Honor. May we be excused?
Yep. Thank you.
Thank you. Thank you,
Appreciate y'all
Judge.
waiting.
Thank you. Appreciate it, Judge.
And next, Mr. Green.
Paul Jackson, Your Honor, in custody.
Mr. Jackson, come on up. All right, this is cause number CR 19-0283-173, state of Texas versus Paul Jackson, and that is set today for arraignment. Mr. Green.
Judge, Mr. Jackson's name is spelled correctly on the indictment. He understands what he's been accused of, would waive the reading of that indictment and enter a plea of not guilty.
All right, Mr. Jackson, the court notes your plea of not guilty for purposes of arraignment. Your two next court dates are May the 12th at 1:30 for discovery status, and then again on June the 9th at 1:30 for pretrial. So if you get out of jail between now and then, I need to see you back on May the 12th. Stay in touch with Mr. Green. Thank you, sir. Have a seat.
Judge, on the pretrial on June the 9th, I'm going to be out of town on vacation that week. Do you want to just address that date when we are back here on May the 12th, or do you want to do it today?
Kevin says we'll address it later, so we'll address it later.
Perfect. Thank you, Judge. That's all my business, may I be excused?
Sir, appreciate you waiting.
Yes, sir.
All right, I'm going to go ahead and go through the docket. If I call your name, just let me know that you're here. You don't have to come up. Lamonte Rodriguez. Gotcha. Your attorney, I guess he's on his way. Where's he at?
He appeared for Judge Williams.
No. That's Zoom. There's Williams. That's Zoom. My wife showed up yesterday and he said, I'm not going full time until April. And she said, oh, but he let her do it anyway.
His dog started.
Lee Floyd. All right. And Miss Moore, I think, is working on that one. Raymond Whitaker. Your attorney, I think, is working on that one. Is that right? Philip Young. Okay. Jessica York.
Marissa talked to her earlier and she did not answer. So
Let's do that. Is there a Jessica York in the courtroom? Cause number CR 20-0680-173. State of Texas versus Jessica York. Bless you. Is there a Jessica York in the courtroom? Hear no answer. Not an answer for Miss York in the lobby. Is there a Jessica York appearing via Zoom? The only Zoom participants are the court staff. And so the time is now 9:50. Arraignment was set at 9 a.m. She does have A to Z bonds. And court will entertain a motion.
Same moves for bond forfeiture, Your Honor.
Granted, case or issues shall be held with no bond.
Let's send notice to her address. Let's do it on-
All right, well, we'll go, anything ready? We'll go ahead and take our morning recess. And so y'all just let me know when we got something ready.
We left John,
Chris.
Robin,
James, too. Yeah. James, yeah, I think James Mills, James Mills. Like were you, James Mills?
this way, Barry.
Your office date is.
Oh, sorry.
All right. Let me see it. Thank you. All right, continuing on with open announcements on the morning docket. Anybody ready on anything?
Yes. ma'am. I've got Mr. Brandon Whitaker for plea.
Any drug test back yet? Oh, okay. He was- Documents in order here.
Oh, it's 392. Gotcha.
All right. This is cause number CR 19-0851-392, the state of Texas versus Raymond Lee Whitaker. Set for a plea today. Is the state ready?
We're ready, Your Honor.
And on behalf of Mr. Whitaker,
Ready, Your Honor.
sir, is your name Raymond Lee Whitaker?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury for the third-degree felony offense of possession of a controlled substance?
Yes.
If I can get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
You can lower your hand. Mr. Whitaker, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes.
And Mr. Whitaker, have you ever been treated for any mental health or emotional issues?
No.
Do you understand what's going on in here today?
Yes.
Mr. Scott, do you believe your client is competent?
I do, Your Honor.
The court's going to find that he is competent. Mr. Whitaker, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment against you out loud here in our courtroom?
No.
But do you understand the charge?
Yes.
Well, as indicted, that charge is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes.
The plea bargain?
Your Honor, it's 24 months confinement in a state jail felony facility. We're asking the court to probate that for 4 years. He's got 26 days credit towards a future sentence. $600 fine, attorney's fees, court costs, lab restitution fee, and we are asking the court to consider a bail jumping failure to appear from December 11th, 2019.
Is that your understanding of the plea bargain, Mr. Whitaker?
Yes.
Is that your understanding, Mr. Scott?
Yes, Your Honor, it is.
All right, well, Mr. Whitaker, a few minutes ago, you told me you could read and write the English language. You've got 2 documents I want to go over with you. The first is the agreed plea recommendation. Did you read both the front and the back of that document with Mr. Scott?
Yes.
And did you sign the front and the back?
Yes.
Do you have any questions about it? The next document I want to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with?
Yes.
Did you sign that second page?
Yes.
Do you have any questions about it? Do you have any questions about any of the documents you read and went over with Mr. Scott related to this plea?
No.
Well, if you read and went over these with Mr. Scott, I know he explained to you that you have many constitutional rights, including the right to trial by jury. You want a jury trial in this case?
No.
Do you want this plea bargain?
Yes.
Then I'll ask you, sir, how do you plead to that third-degree felony offense? Well, I need to back up because, sir, actually, I gave you the punishment range on a third degree. It's my understanding, based upon the plea bargain that was recited and the documents, that the state is willing to reduce this to a state jail felony possession of a controlled substance. The punishment range for that is not less than 180 days, nor more than 2 years in a state jail felony facility, and a fine not to exceed $10,000. Do you understand that punishment range? Then I'll ask you, sir, how do you plead to the lesser included offense of that which is charged in the indictment, the state jail possession of a controlled substance? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes.
I'll hear the evidence.
Judge, I have states 1 an offense report, states 2 is Michael Morton compliance, and states 3 is a live report.
No objection, Your Honor.
Admitted. Anything else from the state?
No, Your Honor, rest and close.
Rest, Your Honor.
All right, Mr. Whitaker, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included offense, the state jail felony possession of a controlled substance. The court will follow the plea bargain, considers that unindicted bail jumping, and sentences you to 24 months in a state jail felony facility. However, the court will place you on community supervision, probate it for 4 years. You do have 26 days credit, orders you to pay your fine, attorney's fees, court costs, and lab fee, and to abide by all the regular and special terms and conditions of community supervision. And Mr. Whitaker, have you ever been on probation before?
No, sir.
All right, well, there's a lot of things you have to do and a few things you can't do on probation. You know what can happen to you if you violate this probation?
Yes.
What can happen?
Up to 2 years, they do.
And do you know how state jail time is served? Generally day for day, that's right. Here's what can happen. If you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest. You'd be brought back before the court. If you'd have a hearing, and if the court found that you violated even one term or condition, the court could revoke your probation and sentence you up to 2 years. So would you agree with me? It's extremely important you abide by these.
Yes.
I hope you do, sir. Before you go, though, now that you have been convicted of this felony offense, you are now under Texas law and eligible to possess a firearm or ammunition. If you have any questions about that, there's a document in your plea packet where you can consult with an attorney. Good luck to you, Mr. Whitaker. Mr. Hunt with the straight from misdemeanor court. Oh, hold on, Mr. Scott, you got another one?
I do. I've got 2 more, Your Honor. I've got Brandon Black. You had sent him off for a drug test, and I got the results back.
All right, Mr. Black, come on up.
You have your copy, Judge.
Sure do. All right, this is back on the record in cause number CR 21-0005-173. State of Texas versus Brandon Black. Mr. Black was sent off for a drug test due to the nature of his charges. The test has come back and it appears as though he's tested positive for methamphetamine. And it looks like that he was admitted that he was around people using meth on March 19th. I'm not aware of a single documented case where somebody that was around somebody that was doing something tested positive. But oh well. All right, Mr. Black, everybody gets their first free chance in this court. And so I believe in second chances. So this is your first time to test positive, right? Was this arraignment? Yes. Okay. All right. And so, Mr. Black, if you don't know it, was this my grand jury? Was it CR 21? Okay. Well, Mr. Black, I'm going to place you on conditions of bond. First of all, no drugs unless they're prescribed, no illegal drugs, no marijuana, no matter what state you're in or state of mind, it's still illegal in Texas and the United States. No alcohol, and I think that don't commit any new offenses. So if you need help, just ask. And if you have any questions about that, just consult with your attorney. Y'all are doing the bond sheet. All right, Mr. Black, we'll see you back in May. And I'm gonna drug test you again in May. You just did Raymond Whitaker, right?
Yes, sir.
That's what we
I'm gonna email.
did. You have Phillips Young?
Okay. Philip Young, Your Honor.
Mr. Young. Come on up, sir. What are we doing, Raymond?
Yes, arraignment, Your Honor.
All right, this is cause number CR 20-0687-173, the state of Texas versus Philip Young. Actually, there's two cases. The next one is CR 20-0688-173, same style, both set for arraignment. Mr. Scott.
Yes, Your Honor. Got both indictments here. His name is spelled correctly. He understands the nature of the charges against him. Will waive formal reading and enter a plea of not guilty to both cases and a plea of not true to the enhancement paragraphs in both cases.
All right, well then, Mr. Young, court notes your plea of not guilty for purposes of arraignment and not true to any enhancement paragraphs. Court giving you your next two court dates is May the 12th at 1:30 for discovery status, and then again on June 9th at 1:30 for pretrial. So we will, if you get out of jail between now and then, we'll see you back in May. What happened to your head? That happened in the jail?
No, sir.
Okay.
Yes, sir. That's the last one I've got, Your Honor. May I be excused?
All right, yeah, so you had a good experience at the VA?
A great one. Yeah, I mean, sad, but yeah, it went as well as I could expect.
Good.
Yeah, it's nice. They just have a walk-in lab.
Yeah.
I could have gone when I went to have my doctor's appointment, but I'd have to get there at 6 and
Yeah, and then it takes a couple hours for them to get to your
Right.
office. That way you do it, and then when you go, they'll already be there.
yeah, the parking was fine. And I mean, it was pretty crowded, but
Yeah. Even before COVID, it's a nightmare.
I can imagine. Yeah, I appreciate the advice.
All right, no problem. Mr. Hunt. Lamonte Rodriguez. All right, these are cause numbers CR 21-0065 and 0066-173, both styled the state of Texas versus Lamonte Rodriguez, and both set for arraignment. Mr. Hunt.
Your Honor, this is Mr. Rodriguez. We have received copies of the indictment. His name is spelled correctly on both indictments. He understands the charges against him, waives the reading of the indictment, enters a plea of not guilty at this time.
All right, then, Mr. Rodriguez, the court notes your pleas of not guilty for purposes of arraignment. Your next two court dates are May the 12th at 1:30 for discovery status, and then again on June the 9th at 1:30 for pretrial. And so you're going to receive those in writing. So if you get out of jail between now and then, I need to see you back on May 12th at 1:30.
And Your Honor, I believe we have a writ for bond reduction set for Monday at 1:30 also.
All right,
So
so
we'll
then,
be
Mr.
back.
Rodriguez, we will see you Monday at 1:30.
Yes, sir.
All righty, thank you.
Thank you, Your Honor. May I
Yes,
be
sir.
excused?
Yes, sir. All right, and you told me a Jessica York showed up. Miss York, come on up. It's cause number CR 20-0680-173, the state of Texas versus Jessica York. And Miss York, you were set for arraignment today, and we called your name, didn't we? That's what, yeah. And you weren't here at 9 a.m. What happened?
I had some issues at my house.
Issues at your house? Well, I think I said this yesterday. There's two things you don't want to be late for. One is felony court, and the other, I said your funeral, but my wife said that I should have said your wedding. Maybe birth of a child. If you're a man, I guess. If you're a woman, well, yeah, I can't get into that because there's all kinds of genders now, so I don't want to get canceled. But anyway, here's the deal. You got to be here at felony court when you're supposed to. You understand?
Yes, sir.
All right. Don't be late to felony court. Do you have an attorney?
No, sir.
Have you filled out paperwork to apply for one, or do you want to hire one?
I'm gonna hire them.
All right. And have you talked to anyone? You knew you had arraignment on a felony case today, and you hadn't talked to an attorney.
I've talked to them.
Okay. All right, well, I'm gonna reset your case. Did we reset her arraignment? How long do you need? At least a month or so.
Let's reset her from May 13th.
All right, I'm gonna reset your case, Ms. York, to May 13th. What time? 9 a.m. May 13th at 9 a.m. If you're not 15 minutes early, you're late. That's the way I like to look at it. And so make sure you have an attorney by then. Let them know of that date. And we'll go from there. I am going to ask you today, ma'am, based upon the nature of your charge, take a drug test. So I'm going to order you to take a drug test. You'll go with probation. You'll take the test. When you get done, you'll come back in the courtroom and we'll go over the results together. Okay. So don't leave until you come back in the courtroom and we talk about it.
And Your Honor, regardless of the results of the drug test, the state's can ask that DWI bond conditions be
Right.
imposed.
They with Calhoun, well, they should be since it's mine.
We'll double check while she's taking
Okay.
her UA.
Go ahead and take that drug test, ma'am. Yeah, and I'll recall the bond forfeiture.
Kevin, what day did the arraignment get reset to?
May 13th.
9
Does have conditions. I'll put
I figured she did. She's mine.
1:30 or 9?
9.
She does have DWI conditions.
Yeah, I'm printing them.
All right, if I could get Jason Passons and Donald Snyder up here, please. All right, these are cause numbers CR 21-0044-173 and CR 21-0043-173, the state of Texas versus Jason Passons, and CR 21-0027-173, the state of Texas versus Donald Snyder. Both of these gentlemen appeared for arraignment today. The court, based upon the nature of the charges, ordered a drug test. And it appears as though both of you, almost like y'all were at the same place at the same time, meth and smoke marijuana. Oh, there's two different dates. Okay. All right. Well, both of you have tested positive for meth, amphetamine, and THC, and both of you admitted to meth and smoking marijuana just on two different dates. And so, gentlemen, I believe in second chances. You know where you stand now. I'm placing, you probably already have conditions of bond. No, they don't. It's CR 21. I'm placing conditions of bond on each of you. No alcohol, no drugs not prescribed, no illegal drugs, no marijuana, no matter where you're at, and don't commit any new offenses. And so we're going to get you those in writing. And once you get copies of those, you're free to go. We'll see you in May. And when you show up, there's a really, really good chance that you'll be tested again. If you test positive, then you're not going to go out that door. You're going to go out that one. And if you need help, ask somebody. There's lots of help out there.
Yes, sir.
All right.
Thank you.
So if y'all can have a seat, don't go anywhere. They'll get those conditions. And once those are in your hand, you're free to go.
Yes, sir.
Mr. Snyder.
Snyder. Ms. Moore, you got anything ready? Okay. I'm here all day. It's all right. All right, Miss York, come on up. All right, we are back on the record in cause number CR 20-0680-173, the state of Texas versus Jessica York. Miss York was ordered to take a drug test based upon the nature of her charge. Miss York, it appears as though you have tested positive for methamphetamine and amphetamine. And it looks like you admitted to the officer that you had touched the illegal substance. That can mean a whole bunch of stuff. Either way, it's your first arraignment setting anyway, Miss York. I know that you want time to hire an attorney. What I'm going to do is you should already have conditions of bond, but I'm not quite sure they're the same here. Yep, you do. You already had conditions of bond, ma'am, when the indictment was, when bond was set on the indictment. And I'm going to read them to you. You shall abstain from using any alcohol, illegal or controlled substances not prescribed. You shall have installed on the motor vehicle owned by you or driven by you a device that uses deep lung breath analysis to make impractical the operation of a motor vehicle if ethyl alcohol is detected in the breath of the operator. The device shall be installed at the defendant's expense before the 30th day after the date the defendant is released on bond. And that's probably already passed. I'm ordering you to do it as soon as practical and before you operate that motor vehicle again. I know you probably drove here, but you need to do it soon.
Oh, I have one.
But you do?
Yes,
Okay.
sir.
And you shall not operate any vehicle unless it is equipped with a device that uses that analysis to make impractical the operation of a motor vehicle if ethyl alcohol is detected in the breath of the operator. And do not commit any new offenses. And I'm going to add this, an illegal substance is still marijuana. I don't know whether I see you're positive for that, but I don't care what state you may be in or state of mind, no marijuana as well. And so this copy, is this hers? This copy is for you. Make sure you let your attorney know. Thank you that of your new reset date and that. And how old are you, Miss York?
Sir.
How old are you?
32.
32. And this is your third alleged DWI. There's all kinds of help out there. I help you by putting you in jail and detoxing you because sometimes it's the safest place for you and those around you. But there's other help elsewhere. So here's the deal. If you come back in and you test positive in May, I can't promise you'll go out that door. You may go out that one. All right. We'll see you in May.
Thank you.
Good morning.
Morning. How are you?
I'm fine, thank you.
They're all over the county.
What?
Our YouTube watchers, they're all over. Right, Rod Mark, backseat driver. We're losing viewers, Judge. We're down to 5. Shoot.
Somebody needs to do something, do it now.
I think I livened it up.
I'm reading tax case law. That ain't live.
Yeah, that ain't gonna do it.
Are we ready?
Yes.
Mr. Floyd. Come on up, Mr. Floyd. So reigning first. This is cause number, you ready? CR 21-0017-173. The state of Texas versus Lee Floyd and set for arraignment. Ms. Moore.
Your Honor, we are ready on a plea in cause number CR 19-0080-173. That case has been,
Oh, I didn't call them all. Sorry.
and I don't even know, I don't think it was set today. But he has this CR 19-0080-173 is set on your docket for the first time on Monday. I believe it's on Monday. It's
I got you.
pending trial, and we've resolved that case as well as his new case,
Okay.
and would ask the court to hear that plea bargain.
Well, I'll still want to arraign him. And so as to the CR 21-0017-173 for purposes of arraignment, how does it plead?
He would plead not guilty.
All right, then the court note your plea of not guilty for purposes of arraignment, Mr. Floyd, in that case. Now, moving on, I'll call the case of CR 19-0080-173, the state of Texas versus Lee Martin Floyd. A plea has been presented to the court. On this case, is the state ready?
We're ready.
And on behalf of Mr. Floyd,
He's present and ready.
sir, is your name Lee Martin Floyd?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury for the second-degree felony offense of possession of a controlled substance?
Yes, sir.
I can get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God.
Yes, sir.
Lower your hand. All right, Mr. Floyd, can you read and write the English language?
Sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
Mr. Floyd, have you ever been treated for any mental health or emotional issues?
No, sir.
You understand what's going on in here today?
Yes, sir.
And Ms. Moore, do you believe your client is competent?
I do, Your Honor.
The court's going to find that he is competent. Mr. Floyd, I know that you have already been arraigned on this case. However, would you like the district attorney to read the indictment against you out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a second-degree felony. A second-degree felony carries a punishment range of not less than 2 years nor more than 20 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
And the plea bargain?
Yes, Your Honor. The plea bargain is for 12 years TDC with payment of attorney's fees and court costs and a $180 lab fee, considering cause number CR 21-0017-173 and unindicted unlawful possession of a firearm by a felon and 2 misdemeanor offenses.
Is that your understanding of the plea bargain, Mr. Floyd?
Yes, sir.
Is that your understanding, Ms. Moore?
It is, Your Honor.
Mr. Floyd, you told a few minutes ago, you told me you could read and write the English language. I'm going to go over a couple documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that document with Ms. Moore?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
Do you have any questions about it? The next document I want to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that with Ms. Moore?
Yes.
Is that your signature there on the second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Ms. Moore related to this plea?
No.
Well, if you read and went over these documents, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No, sir.
Do you want to enter into this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that second-degree felony offense? Possession of a controlled substance as alleged in the indictment. Are you guilty or not guilty?
Guilty, sir.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I hear the evidence.
However, states 1, a copy of the offense report. States 2 is a copy of our case submittal inventory, and states 3 is a copy of our supplemental inventory and lab report.
No objection.
Admitted.
State rest.
Your Honor, if I could put a couple of things on the record. With Mr.
Sure.
Floyd.
He's under oath. Go ahead.
Mr. Floyd, we were just set for an arraignment on your new case today, correct? And you understand that I had filed a motion to withdraw. You really didn't want me to withdraw. It didn't have anything to do with our working relationship with each other.
Right.
It was in the event that we were going to go to trial on this case that you're pleading out on, that I was potentially going to have a conflict that I realized. You
Yes.
understand that?
Yes, ma'am.
But you don't want to have a trial on
No.
that case, correct?
No.
And you don't want me to withdraw, correct?
No, I don't.
In fact, when I asked you, you said, no, I don't want you to
Uh-huh.
withdraw. So you're comfortable going forward knowing the
Yes.
potential conflict that I had. right? And we've discussed that, but you didn't want to have a trial anyway, correct?
No.
And you're satisfied with my representation of
Yes,
you?
ma'am.
And you're agreeable with your jail credit and what we've done here today, correct?
Yes.
And you're asking the court to follow the plea bargain?
Yes.
Okay,
yes.
I pass the witness.
No questions.
Anything else?
No, Your Honor.
Close?
We'd rest in closure, Your Honor.
All right, then, Mr. Floyd, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that second-degree felony offense of possession of a controlled substance as alleged in the indictment. I want to say you abandoned in 1 and 2.
We did, Your Honor.
So would 1 and 2 have made it 25 to 99?
It would have. Your Honor.
Okay, all right, look at the indictment. All right. So the court finds you guilty of that second-degree felony offense as alleged in the indictment. The court will follow the plea bargain, considers those cases that are annotated in the plea recommendation sheet in sentencing you, sentences you to 12 years in the Texas Department of Criminal Justice with 167 days credit, and orders you to pay your attorney's fees, court costs, and lab fee. And a couple more things I need to go over with you, Mr. Floyd. First, did you have an opportunity to review the judgment of conviction in your case?
Yes, sir.
Is your name, the charge, and the time credit correct?
Yes. And can I get a copy of that, please?
Yes, sir. The clerk can give you the copies of all of this.
Okay.
And finally, sir, now that you've been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about what that entails, refer to the document in your plea packet or consult with an attorney. Sir, you're now remanded back to the custody of the sheriff for transport to the appropriate authorities to serve out your sentence. Good luck to you, Mr. Floyd. Need to
Thanks,
see the
sir.
bailiff to your right.
And Your Honor, that's all I have for this morning. May I be excused until 1:30? Thank you. Thank you
We'll be
for,
here.
waiting on me. Appreciate it. Maybe-
Yep, I'll wait if we're going to resolve a case.
Thank you.
Resolve a number.